All right, we are getting this started. One moment. Very good. Okay, looks like we are live. Welcome everyone. I'm Seth Stewart here on Truth from Earth. This is our fifth human rights panel discussion in our series. I didn't get the invites out for this until a little bit late today, but I was wanting to review the legislative session that just ended here in the state of Utah last Friday and go over some things that are potentially impactful with respect to human rights. This is a big issue because legislators, they get to basically make up whatever rules they want for how things are to be run, and so it's kind of impactful, frankly, when they get a hold of just whatever they want with respect to writing laws. Uh, let me just dive right in here. I'm going to go ahead and pull up this website. It's called citizenportal.ai if you've never seen it before. Second, sharing my screen here on it. And what it does is it enables you to go to your specific state and find legislation and things that are impactful, things that are significant in that area. Sorry, give me a second. Still pulling up the window. There we go. All right. Hopefully that's coming through all right. But yeah, so you can navigate here to your state. Again, it's citizenportal.ai. This is a great tool that was brought to my attention. I still haven't learned all the ins and the outs of it, but you can go and search bills, legislation by topic, and so on. And one that I've been concerned a lot about is defendant rights. Obviously, we've talked about money, inflation, fiscal stuff, and so on. So what you just type in a topic, and we'll give. I think this is an AI summary right here. And you can just have a chatbot in the loop basically and help you get familiar with the contents and context of a particular bill, which I think is tremendously valuable. Frankly, this is something I should have made use of a lot earlier than I did in this space because conversational AI, it's disruptive. It's very useful in this field because historically you've had to have lawyers with and legislators with paid interns, a paid legal staff basically to go in and get visibility on any of these things, or else you have to have your own legal training, and then you have to go and spend your own time, which it's completely infeasible for any human being to actually get eyes on all of the bills and legislation that they're trying to pass in a given legislative session. So having the assistance of technology to do that is an enormous blessing. I would also strongly recommend, by the way, and this is one of the ways that I'm connected here, is through the delegate system in my state. Is there are a number of people, dozens of people who are pretty well connected in the political space and very concerned citizens mostly, who just do keep an eye out for stuff. And this is how you get, they raise the alarm and they say, hey, this particular issue looks impactful. I think we need to go and pay attention to this thing and so on. That's where a lot of my tips come from, frankly, when it comes to these kinds of things. But yeah, invite you to check out the Citizen Portal tool, citizenportal.ai, and that gives you some pretty sweet tools for, examining, jump to your state bills. The legislative session just ended, so, but yeah, let me just do that again for context. Give me a second. Go to Utah. Yeah, okay. So yeah, they were productive, right? They got a lot of bills through. And I strongly object to this, by the way, because let me just for context, like all warfare is ultimately economic. And I saw this big time during this last legislative session. It lasted 7 weeks, beginning right around the inauguration. until last Friday. And yeah, they're if you want to speak up on a particular issue, you got to be able to like take the time off work, or you can join remotely. Um, it's more impactful if you are physically there um, at the Capitol building to testify in these hearings and so on. If you have a particular concern in these things, they have people show up. It's pretty interesting. Um, but yeah, I did want to go into several specific bills because let me just show you right here. This is the Utah, so le.utah.gov, LE standing for legislature, I guess, not law enforcement. Be a problem if legislature and law enforcement were one and the same. And you can go through and you can look at legislators. Bills, that's the big thing. They have a tracking service where you can uh, basically sign up for alerts. You can get email alerts on bills as their status gets updated, so you can track them. That was very useful during this past session. I was able to get updates on some things. You can look at the past bills and you can look at the session itself. For if you are just looking at a calendar and you're like, you can come at this from a couple different ways, frankly, and I think we need both. One is to say, well, I have Friday off work, so you can say, all right, what's on the docket for Friday, right? This is an approach that I took because I just got back from some leave time, and I had some free time during the session to actually weigh in on some of these things, which was very helpful. But you could do it that way, and if you do it that way, my recommendation is just look at the weekly schedules right here, and they have whatever the current week is. So last week I went on here and I was like, okay, what are the committees that are meeting each day? Because whenever you have a committee meeting with a hearing, they will often have it open for public comment if they're considering one of these bills, either in the House or the Senate. So this is the House schedule for week 7. So I'm like, okay, judiciary, that's pretty interesting. Let's go ahead and open that link. And okay, they canceled that, so they don't have that on that day. So let's go ahead and skip out on that one. But okay, law enforcement, criminal justice. Let's go ahead and check that out. And here we go, meeting material list. So this is kind of the outline that you can expect them to follow. Is they'll have SB 252 sub 3. So that's what the S stands for, substitute. They'll have substitutes, they'll have amendments, and so on. So constable amendments, assault modification. So if you have a specialty like AI, artificial intelligence revisions, you can find that through here. You can also find that through Citizen Portal just by doing the topic search. But if you're looking at a particular session, this is what's on their agenda, their docket, and you would typically add in. There's usually a link up here if it's like upcoming within the next, I don't know when it goes live, but maybe an hour in advance. I don't know. I was able to see and join the audio and video link, a handful of minutes before the actual session started. So you keep an eye on that, and you're able to drop into this meeting, and it's through Zoom, and so you can raise your hand in there if they're calling for public comment on any of these bills, and you can just say, hey, I have a comment on this, and they limit you typically to 1 or 2 minutes, 2 minutes if they've got plenty of time. If they're rushed, maybe 1 minute. There was a time when I was raising my hand, they're in the courthouse in person, and they skipped over me because they're like, we already heard all the people we wanted to hear, kind of thing. I don't know what it was, but and I understand they have to call it at some point, but my humble take is if you got people who are there weighing in and they traveled up there to talk, it'd be good to hear them. Anyways, so yeah, you can go through them on that note. Fair warning here, like what I found in my experience diving into this is that there were a fair number of times when things were tucked into a session where it was just kind of like, well, that's kind of weird for that session. So like, transportation. You'll find some of these topics absolutely riveting if you're not, specialist in them, I guess. Dietitian licensing amendments. It's like, anyways, but it really does help to listen in on these things and just become aware of these things. But like, joint resolution amending rules of civil procedure on injunctions. That's pretty important, actually. And what in the world is that doing in a transportation committee hearing? I don't know, but they will actually squirrel these things away. So SJR 9 and let's see, SGR 12. I actually read both of these, and I spoke up on both of these because these are actually, there are some serious poison pills in here. So things you wouldn't expect to find just, the House Transportation Committee. Oh, transportation, they're just regulating commerce. They're just, and limiting people's ability to appeal, a suspension of and appeal the enforcement of a law. They try to get a law suspended while its constitutionality is being reviewed. That's what this is. This is a major poison pill, and they just ramrodded that. Anyways, that was very troubling. So I could dive into some of these. I understand that this is probably not the most fascinating topic for a lot of people because when it comes to these laws, you just get hit with this wall of text. But again, I think this is where it's really helpful to have some tools at your disposal, like the Citizen Portal, keyword search. Even that there are news articles, and that was actually how my attention was originally drawn to this to SB 50. Sorry, SB 203 and sorry, SB 54 has been on my mind a lot this last year. You can tell. SB 203 and 204. That's not the right SB 203. But yeah, check the news. Because you'll get headlines like this from time to time with other concerned citizens and with reporters who are out there being like, they're trying to give coverage of the legislative session, and that can be extremely helpful because you can get the takes of some professional people and some actual lawyers and so on a lot of these topics. And I actually phoned up one of them about the SB 203 and SB 204 issue. I said, "Hey, what's going on here?" And got some additional context on it, which is enormously helpful. So when you find somebody in one of these articles that's talking about here's what's wrong here, here's what's going on, and they have like public contact info, and you're concerned, you want to weigh in, feel free to reach out to them. Like that's usually why they talk to the media, is so that they can get people who are interested in that. Well, get people interested in it in the first place, because a lot of people aren't as interested as they should be or as informed, right? And you can reach out and you can get some action on those things. But yeah, so testifying in these committees, it's really helpful. But yeah, like you can read through an article like this, and you can get insight into things like what are people concerned about here already. Um, and yeah, just there were instances. I'll just go ahead and because I don't know how many things I ended up testifying in, but I showed up to a number of these hearings on several different days and raised my hand maybe probably a total of 12 times to testify in these hearings. I don't even remember how many, but because there were so many poison pills, there were so many things that just keep you on your toes. And just kind of, I can share the footage. I'm actually working on a video over two where I'm stitching together some of the footage because they keep the footage uploaded on the site for each of these sessions. So if you go back to the House Transportation Committee, you can watch the audio and video here, and there we go. You'll see my mugshot here at some point. I joined this one online, and just to testify on a couple of these issues. And yeah, my observations, just at a high level first, are they do take public input seriously sometimes. And that sometimes is real kicker. It's real pain because you can bring issues that are very legitimate, that have lots of public support for your position on an issue, and they can still just totally ignore you and railroad you. There are times, however, when there's sufficient public pressure on something. I did see this occur several times, where a legislator will speak up and say, during they have some time for debate and questions coming from the committee itself, the committee members, including your own legislators. And I saw it happen that one of them says, yeah, I got a ton of emails on this saying it's a really bad idea, and I've looked into it, and yeah, I agree with my constituents. I don't feel like I can betray them, so that legislator might vote no on favorably recommending this piece of legislation, this bill, to move forward, and so on. So it does matter when you let your voice be heard. There's only so much that they can get away with. And of course, the more we let them get away with, the more they'll be able to get away with. So it's this compounding problem here. Um, Let me go ahead and let's see. I think I wanted to show some examples of just kind of what some of these pieces of legislation look like, some of the poison pills that we saw, and then I'm going to go into any comments, any chats, and so on. If anybody has any bills that you want me to look at in particular, please do let me know. So I'll just be monitoring the live chat there. So let me move this to live position here so I can make sure I'm up to speed on that. But yeah, some of the ones that I was initially most concerned about, like I mentioned, was like SB 203 and SB 204. I just like rolled out of bed one day and I happened to swipe on my phone to the part where it shows like the news. I don't normally check the news, frankly, but this was very fortuitous. It was a great blessing that I did because it turned out that there is this SB 203, SB 204 being sponsored by my own senator, by the way, the guy we just barely elected through a special election last year, towards the end of last year, and I did a video on that. Well, sorry, there was yes, I did a video on the special election, and yeah, this guy, I talked to him like I should have researched him a whole ton better than I did ahead of time by looking at his legislative track record, but. At first, I was kind of like, I think he's okay-ish, maybe, based on his track record. There were some kind of concerning things. There was somebody else I liked quite a bit better. But then afterwards, like the minute he got elected, he was just like, okay, I'm not listening to you guys anymore. Because I had some specific issues and requests because anyways, I've had multiple conversations with him since and have not been able to reason with this guy because he's just like, nope, I'm in office now. I get to do whatever I want kind of thing. Anyways. So, yeah, on the campaign trail, yeah, these guys can be very, very deceptive. But keep an eye out for things like this. So, Senate Bill 204, titled Suspensive Appeal Amendments. That already makes me cringe. Specifies that trial court injunctions which put laws on hold until they're ruled on would go away as soon as an appeal to that lower court's ruling was filed with the Utah Supreme Court. Okay. So if this was passed, which this particular bill did not pass in this form, they changed the wording out, and I ended up finding a lot of that same functionality being shoehorned into a bill in the Transportation Committee. So this is something that my fellow delegates have alerted me to, is the fact that they do this on a regular basis. It's very slimy. But basically, if there's enough public outcry and pushback on a particular bill, and there's some poison pill that they really want to get through, they're just like, oh, okay, well, let's just amend that to make it look nice. And sorry, we threatened to take away your rights and everything. They don't apologize. But they'll be like, oh yeah, I think that's a fair point. Okay, and they amend the wording of it. But then that exact same function, worded differently, shows up in another bill in another committee somewhere else. It's terrifying. It's like whack-a-mole. It's a Hydra beast with all these different heads. So yeah, SB 204, I went through that one, and massive, massive concerns because basically they erased checks and balances. They were giving the legislature and the executive branches explicit power of judicial review, and that was super toxic. So, and SB 203, judicial standing amendments have more far-reaching effects, as it would narrow the criteria for who is eligible to have third-party standing to bring civil actions against the legislature. So, like, taking together these two bills just at a high level, yeah, SB 203 basically makes it so that you no longer are regarded as having standing to bring civil suits against the government on a large number of issues that you were previously allowed to in an SB 204. Further, like, weakens your position because you can no longer challenge the constitutionality of things, and then the legislature and the executive branch basically get, they get omnipotent powers of judicial review. So this is really, really bad news. I would like to have like a chart, a dashboard. I've actually started to work towards this, to have a website or an extension of Citizen Portal where you can go and actually just like see kind of a graphic depiction of your rights and the checks and balances in government, and like kind of have status indicators like, hey, this is our, we're looking at the Constitution, we're looking at the Bill of Rights. What's the status? Damage report, on each of these bills in legislative sessions so that you can see the threats in real time, coming in on a kind of a radar view. And when they crop up in some different wording, we urgently need those proactive tools to go and highlight those threats for us. That's what I found here. We urgently need that tool, so I've begun developing that. Let me know if you have ideas or you want to collaborate on that. Because yeah, there's just too much to keep track of, and that's one of the things that we learned here is I could spend this entire live stream just going through one of these bills, going through with a fine-tooth comb on all of its wording and all the possible poison pills and pitfalls, and reality check, we're not going to find all of them most likely. Even if we do just totally canvass the area, that would be awesome, and we have the manpower to do it. By the way, if we just decide that our freedoms are more important than whatever soap opera, whatever the latest egregious thing on X is, or if we decide that our freedoms are more valuable than entertainment, then we can actually sustain this, even without the aid of AI. But now that we have these tools, I think there's really no excuse not to be using them. So, and I did use chatbots on a number of these to just kind of summarize. If it was a really long bill or whatever, I'd be like, okay, I'm just pasting that in there and be like, okay, tell me what possible constitutional issues there could be with this. And then I would go through those that were highlighted by the chatbot and verify them, confirm them in the text itself, and that would actually give me a list of talking points for these hearings. And anybody, you don't have to be a subject matter expert on XYZ to be able to say, hey, you guys are trying to limit our standing. You're trying to give powers of judicial review to the legislature. That's unconstitutional. We all know that. And what it mainly takes is for somebody to notice that and then just speak up about it. So you don't have to be a lawyer. You don't have to have, a ton of political or legal training. I have none. I'm just a computer scientist, and maybe there's some overlap between the concepts in lines of code versus, lines of illegal code. Primary difference being the legal code does not compile. It's not consistent with itself. But whereas computer programs actually need to compile and do something useful, and basically you don't have a job if you can't make your code compile. Politics isn't like that. But they do try to just overwhelm you with these walls of text. So anyways, it's not my intent here to read through this entire article. It's intended to be very reachable type of language. But yeah, go ahead, and if you have a question on a particular topic or a particular bill, go ahead and avail yourself of the news, as well as get connected with friends who can point things out to you. Because if you can't explain something in a reasonable fashion, we got to keep it grounded, basically, because this is what it comes down to, is there's something particular that's gone wrong here. And I wanted to give a quick illustration of this on this joint resolution calling for an executive order on federalism. There were multiple such joint resolutions that were issued as bills during this past legislative session. And I want to point out, this is a national movement in the first place. The federalism issue, we're going to go into some of the language here. They reused a lot of this boilerplate across these joint resolutions on federalism. And there are poison pills in here. And I just opened this up. Basically, my recipe here was kind of, you look at a session or you look at a list of bills, you look at ones that are upcoming that you can actually do something about, raise the alarm about. And in any of these committees, so yeah, I look at that and I'm like, executive order on federalism. Huh, that sounds interesting. I like federalism. So I open it up and I'm like, okay, what does this even say? And of course, they have this highlight up here, which is sometimes truthful, often not. Often this is kind of the pitch that the bill's sponsor will give you in the hearing, some variation of this, saying this is what this thing does, and this is what I claim. But if you look in the text, this is why we actually do need to go into the text, because it's got some big differences. So expresses, let's just do a compare contrast here. This is going to be a fun exercise, all right? So this resolution expresses the importance of maintaining the principles of federalism and respecting the balance of powers as required by the United States Constitution. So, okay, you already know that I'm saying this has got poison pills in it, right? But suspend that maybe for a moment and just be like, okay, what if you were reading this? Do this exercise yourself. I really invite you to do that. Just look at one of these sessions, open up a bill that looks interesting or uninteresting, and just be like, okay, let's see what's in here. Do it multiple times. You'll learn a lot. It calls on the President of the United States to issue an executive order that reaffirms and strengthens the principles of federalism through certain self-enforcing mechanisms. I had at least two questions when I saw this. I saw one. I said, one, why are they calling on the president to issue an executive order reaffirming federalism? Uh, hmm. And second, what does self-enforcing mean? That seems like a very vague and very dangerous concept, honestly. Whenever you have anything in government that is self-enforcing, by definition, inherently, that means there's no check, right? So things shouldn't be self-enforcing in government. They should be enforced by someone who's responsible to enforce it, who should not be the same person who's responsible to create the rules around it, who should also not be the same person who's adjudicating it. Those need to be separate. Separation of powers, all right? So urges Congress to exercise its oversight responsibilities to ensure that federal agencies comply with any new executive order on federalism. So this is kind of weird, honestly. And federalism, loosely speaking, is that the states have greater sovereignty and autonomy than the federal government, and only those powers delegated to the federal government and enumerated in its own constitution are supreme over the states, and everything else is basically the states and the people get to do what they want more so. But we're going to find some things in here that are worth noting. Okay, I'm just going to go ahead and this is kind of interesting. This has got some fascinating historical stuff on it, right? So bear with me. Whereas the principles of federalism enshrined in the United States Constitution are essential to the preservation of the nation's system of dual sovereignty, which ensures a balance of power between the federal and state governments as a double security to the rights of the American people. Sounds great, doesn't it? Whereas Executive Order 12612, you can look this up, issued by President Ronald Reagan on October 26, 1987, articulated the federalism principles that safeguard states' jurisdiction and responsibilities while limiting federal overreach, whereas the Government Accountability Office, in its report titled Federalism, Implementation of that Executive Order in the Rulemaking Process, identified areas where the enforcement of federalism principles could be improved through self-enforcing mechanisms to ensure compliance and accountability. So this is coming from the top down. This is this official Government Accountability Office report coming from our own federal government, right? And so this is a joint resolution at the state level in response to that. That's important. Whereas the erosion of federalism diminishes the uniqueness and diversity of the states, weakens the states' abilities to serve as laboratories of democracy. Okay, I cringe a little bit when I hear that. There is some truth to that. There is some latitude in the Constitution for states to alter their internal mechanisms, but Republican government, remember that, Article 4, Section 4. Anyways, undermines self-governance and local accountability, results in unchecked centralization of government removed from the eyes of the people. That's a problem, for sure. And destabilizes the United States Constitution's vision of a federal government and of limited and enumerated powers. Okay, so they're like, we like limited and enumerated powers, right? For the federal government, at least. So let's pay attention to that. Okay. Whereas states have continued to encounter instances where federal rules and regulations encroach on state authority without proper consideration of the fundamental principles of federalism. Yes, that's true. There's been federal overreach, right? That's kind of at a high level what they're saying. A renewed commitment to federalism would foster respect for the distinct and complementary roles of the federal, state, and local governments and better serve the interests of the American people. Whereas, okay, this is kind of cute right here. Look at this. This is a response to Doge, apparently. Look at this. Whereas decades of ignorance and disregard for the meticulous limits, balance, divisions of state-federal governing powers that characterize American federalism have resulted in multi-trillion-dollar annual deficits and an accumulated national debt exceeding $36 trillion. So we're saying this is incompetence, ignorance, failure to regard the separation of powers and so on, threatening the international reserve currency role of the US dollar as well as the overall national security of the United States. So saying, yeah, there's been some federal overreach that we're very concerned about that threatens us, right? And look, it's only 70 lines long. We're already most of the way done. So now therefore, be it resolved. So all these wherefores or whereases, and then now therefore. All right, be it resolved that the legislature of the state of Utah calls on the President of the United States to issue an executive order on federalism that reaffirms the principles of Executive Order 12612 and strengthens the principles incorporation through the self-enforcing mechanisms recommended by the Government Accountability Office, including requiring federal agencies to conduct thorough federalism assessments during the rulemaking process to evaluate the impact of proposed regulations on states, establishing mandatory consultation procedures with state governments early in the development of federal rules to ensure that state perspectives are respected, creating enforceable oversight mechanisms to hold federal agencies accountable for compliance with principles of federalism and mandating publication of detailed justifications when federal actions encroach upon or supersede state authority to demonstrate that such actions are warranted and constitutionally permissible. So basically saying, hey, President, issue an executive order on this, basically reaffirm those principles, and then make sure you consult us, the states, with your Government Accountability Office. What's kind of weird here, honestly, is like that they defer to this so-called Government Accountability Office at the federal level to kind of safeguard their state rights rather than just kind of openly asserting states' rights. That's a little bit weird. Be it further resolved, the legislature reaffirms the importance of restoring and maintaining our exceptional American federalism structure of government that respects constitutional balance, limits, and division of governing powers, and the sovereignty of the sovereign states. And then be it further resolved that the legislature urges Congress to exercise its oversight responsibilities to ensure that federal agencies adhere to federalism principles outlined in any new executive order. And give a copy to the president, vice president. Anyways, this is something that they said frequently during this, is saying it's a non-binding joint resolution. It's just basically a declaration of saying this is something we'd like to do, this is something we want to do, something we should do. Even these non-binding things, though, can contain some poison pills. So one of my first questions here, and the other ones are arguably even worse on this, but like, why do we need a new executive order on federalism? If we already know what federalism is, then why do we need another one? And furthermore, why are we kicking the can up to the federal government with respect to the Government Accountability Office? Like, are states giving power to the Government Accountability Office? Is that the power transfer that they're trying to facilitate here? Because if so, I have serious concerns, because that actually undermines the principle of federalism. So like all of the federalism bills and resolutions have a similar shared problem in this respect, and other ones, as I mentioned, have it even worse. But yeah, so that raised an eyebrow. And again, you can just paste this into a chatbot and say, what constitutional issues do you detect? And when you ask the chatbot to play detective with respect to constitutionally protected freedoms and checks and balances, it will often turn things up that you might not have found yourself. Oftentimes, of course, it will also just parrot the government school narratives and so on. But so yeah, if we're sincere about federalism, we can just assert it, And anyway, I have brought this up before. There are mechanisms for dealing with the fact of the federal deficit and so on at the state level. It's basically stick to Article 1, Section 10 currency, gold and silver coin, nothing but states can pass laws affirming that, upholding that, and that means they can't inflate our money away because we're actually using real money instead of fake money, and then also don't accept federal subsidies or kickbacks. So that would entail ending the 16th Amendment and various other things, which the states do have power to nullify, by the way. It's very fascinating. Anyways, so we're kicking the can. They're not really choosing to solve the problem. It's basically talk. Say, oh, we like federalism. Let's suck up to the federal government to, and let's give them more power. Arguably, that's how this could be used. Anyway, it doesn't guarantee that it's going to be used that way, maybe, but it could do that. We really need to revisit SJR 9 because this is where some of the poison pills from SB 204 got ported from. I wanted to pull up one more example, though, of a joint resolution on federalism, just for the sake of for demonstration purposes. I'm going to try to remember which. Let's see, past bills. I think it was 6. Joint resolution supporting. Hey, isn't there supposed to be a link? I could do is I could just reuse this URL right here. Okay. This one has. I'll admit my Hawkeyes didn't turn up like a ton of egregious stuff in that last one. Mainly just like, why are they looking to the federal government to support federalism when federalism is a matter of states asserting their rights, right? Anyways, and they're inadequately, they're failing to do that adequately. and then kicking the can up to the Government Accountability Office. Like, okay. This one's even worse. So if you were asleep for the last one, or if you dropped off live stream, whatever, come back. This one's really a doozy. Because I'll not read the whole text, but I do just want to pick out some things here. So it's kind of similar, except it directly cites the 10th Amendment, right? And the 10th Amendment, has to do with, it says that all powers not delegated to the national government are reserved to the states respectively or to the people, right? And so this was to allay fears that the national government might seek to exercise powers not granted. Okay, and just like the other one, we acknowledge that concern. We acknowledge that threat. We acknowledge federal overreach, right? And hence federalism, hence this pushback, in quotes, right? It's not what we think it is, though. It's not what they say it is. So the 10th Amendment is the cornerstone of constitutional federalism and acts as a bulwark against federal intrusion on state authority and individual liberty. Okay, and this right here, this is not good. So, whereas the federal government is a government of limited jurisdiction and powers, whereas the state has inherent general jurisdiction and authority under the state's traditional police powers to enact legislation and regulations in subject areas affecting public welfare, safety, health, and morality as recognized under the 10th Amendment, including over natural resources, water resources, rights, agriculture, education, and energy resources. Okay, this is bigger than an elephant right here. The amount of unconstitutional stuff they just rammed down your throat. Here's the thing. The federal government is a government of limited jurisdiction and powers. Guess what? State governments are also governments of limited jurisdiction and powers, but they just sidestepped that. They literally just said, okay, yeah, federal government, yep, you got to stay in your lane, right? So they're virtue signaling here on the federalism point, states' rights, and they just claim all of these massive powers, general jurisdiction and authority, traditional police powers, and we get to do anything we want with public welfare, safety, health, morality. Look those up in Utah's state constitution. They do not exist. None of those things that they just claimed that they have, general authority to make regulations on and have all this power, and police powers even, to enforce, not a one of those things is actually an enumerated power in Utah's state constitution. And so this is how the federalism bait and switch is happening nationwide right now. Is they're claiming, oh yeah, federal overreach is bad, but states need to go and put that federal government in its place, and therefore we're omnipotent. We get to do whatever we want. And I'm like, okay, so what's actually happening here is the states see this model of federal overreach. They're controlled by the federal government by way of redistribution, funding, and so on, various other dark mechanisms. The national parties, that's a big one. And so they're in lockstep with the federal government. They haven't distanced themselves from that at all. You saw in the last joint resolution, they didn't cut the strings of the federal government's power of the purse to incentivize whatever government programs it wants. Yeah, DOJ has been going after those in theory, but they're actually keeping that power. They're still doing that. They're just not letting you know that they're still doing that. They're giving lip service against it. They're virtue signaling while keeping all of those powers and consolidating and centralizing them, right? So basically, each of these is a pledge of allegiance in disguise to the federal government. I know that sounds super conspiratorial, but you look at what they just did, and they said, oh, the federal government needs limited powers. It needs to limit its jurisdiction and so on, but we get everything. We are gods. We have ultimate supreme power over your life. And that's a massive power grab. So I saw this and I called that out in the hearing, and they basically just ignored me because they don't care about consistency, actually applying limited, enumerated powers themselves. And this is precisely the way that the 10th Amendment is being taken. So when you look at this, and say, as recognized under the 10th Amendment, really, guys, really, okay, you must have a super high IQ. Okay, if you can find in that handful of words right there, in the 10th Amendment, show me where it recognizes that states have all these traditional police powers and general jurisdiction and can make all these regulations about public welfare, safety, health, morality. Like, sorry, that's not in the Constitution. Sorry. Um, anyways, and natural resources, water resources and rights, agriculture, education, energy resources. That's like, so yeah, that's your electricity bill, that's your gas, that's your everything you eat, your clothing, what your kids get taught in school, and water. We need that to survive. Natural resources. That's like everything that exists. Like, this is Orwellian right here. I'm sorry. Why I'm pausing on this is because we need to absorb just how ludicrous this is. No, we never granted our government omnipotent powers over those things. We didn't. If we did, where is it in the Constitution? And so it's kind of an argument from ignorance, frankly, because it says the powers not given to the federal government are reserved to the states, respectively, or to the people. And this is the massive poison pill, citing the 10th Amendment. They leave off the or to the people and just transparently assume in this joint resolution and in all of the others citing federalism and in all the various bills that cited federalism, they just assume that state governments are representative of the people. Now, you go and you look at what happened to the Republican convention nominee, Phil Lyman, for the governor race, and Trent Staggs for the United States Senate last year, and you tell me, honestly, to my face, whether you think that the government of the state of Utah fairly and accurately represents the people. To the point that we could just leave off that or to the people clause from the 10th Amendment, or just glibly ignore the fact that all governments must operate according to their constitutionally enumerated powers, and if they don't stay within those enumerated powers, they're unconstitutional, they're illegitimate. Okay? And here's where they're getting some of this. They say, so this is a top-down thing. So this is all this federal overreach. The effect of these bills, these joint resolutions, is to take all that federal corruption and move it into the states, or even worse, replicate it into the states. So the federal government still has all those powers and all those strings attached, right? And it's also giving all that same corruption and overreach to the states, right? And so it's a disguise, it's a camouflage to the point where they can say, oh, don't worry, we're not doing any of that nasty money laundering stuff anymore, when they are, just 10 times worse than before. And this Loper-Bright decision, this is a Supreme Court federal ruling that was pretty recent, and they say, the United States Supreme Court recently reinforced the principle of federalism in Loper-Bright Enterprises versus Raimondo, the Loper-Bright decision, and it eliminated the Chevron doctrine, a long-standing precedent that required courts to defer to a federal agency's interpretation of law and resulted in arbitrary and unchecked federal rulemaking. So we're saying there's all this precedent. There are these federal agencies that have been making all these arbitrary rules for us. We don't like that. And you can't preempt state sovereignty. And this restores the court's constitutional role in interpreting the law and deters the federal government from exercising powers not given to it. This is great lip service, guys, but the fact that you're saying the federal government can't exercise powers not enumerated, they never actually say that about the state, even though the exact same thing is true of the state. And they're just using the 10th Amendment as their weasel word to get this. And I think part of the reason for having multiple joint resolutions, by the way, on this point, is to, for number one, seize different powers, but also two, offer differing attempted justifications for it. So in the event that the people see it and shoot down one of them, they got more coming at you, and they can put, well, if the 10th Amendment excuse didn't work, then maybe this other one, So we're going to go ahead and use the courts and say that they agree with us. And this is another self-contradictory thing on its face right here is they're looking to a federal court precedent to try to assert their states' rights. And so they're, again, deferring to the federal courts in the name of not deferring to the federal courts and agencies, right? That's kind of weird. And you could argue, okay, courts and agencies, different things. I digress there for a little bit, but it's if you're going to stand up for states' rights, just do it. Just stick within your constitutionally enumerated powers and actually just assert, saying, hey, we're not obligated to accept your Federal Reserve funding money. Pretty simple, right? Hey, we're not going to stand for you seizing our rightful state lands or whatever, Anyways, you stand up to it. And yeah, you do need to work against those things, and you need to set a precedent locally. But again, big red flag, they're not including the people here. Okay, So be it resolved that we affirm Utah's sovereignty under the 10th Amendment, pledge to safeguard states' sovereignty from unconstitutional federal overreach. And yeah, uh, the state of Utah, legislature of the state of Utah calls on the federal government to rein in its regulatory apparatus and uphold the balance of powers where the Constitution of the United States established it. All right. So, again, this is a relatively short one compared to a lot of them. And, they're just citing the 10th Amendment, ignoring the people, and saying basically we're omnipotent. We get to have all these powers because we want them, because federalism. So, that's pretty big misdirection there. Let me just check how I'm doing on time and see if there are any chats coming in. Second. All right, cool. And we will get to those if there are any. So I did want to look at SB 203 in particular, just because this is one of the first ones that my attention was drawn to. Obviously, in no way can I cover everything here. There was a massive bill, SB 377, I think it was, basically empowered this massive beehive development agency thing. We should probably look at that in a minute too. That didn't pass, but I have yet to rule out the possibility that they, snuck it in substantial parts in other places. So we're going to look at this, and then we're going to look at the, let's see, what was it, the SJR? Sorry, it was the one where they snuck in the pieces of the previous one. What was it? I'm not remembering right now. But where they moved the, was it this one? So SGR 12, no, that's the other. So these are the two federalism ones we looked at. Oh, it was SGR 9. Okay, never mind. Yeah, so also a joint resolution. And yeah, this one right here, that's bad too. And okay, yeah, the idea. Sorry, I'm a little bit scatterbrained because there's so much to cover. Guys, it's full on drone warfare right here. We gotta have like shotguns and artillery and the whatever you call the phalanx guns and whatever anti-drone defenses here. Anyways, that's kind of how hectic this is. So pardon my scatterbrainedness. All right, I'm going to go ahead and look at SB 203 now, and we're going to come back to that one, which I believe rolls in some of the poison pills of SB 204 in its original version. So, and this right here is, the enrolled version of the bill, the one that actually is either on track to being signed into law or already has been. All right, so judicial standing amendments. This bill defines terms related to a civil action, provides legislative findings with regard to the traditional standing requirement. Legislative findings, what is that? Okay, and what is this traditional standing requirement? Why do they need to define terms? Were they not adequately defined before? Was something just not working? It's really unclear already that like this, about what problem are they trying to solve, right? And we've asked this question: what problem are you trying to solve? He's ghosted us on answering that question. My senator has. Addresses requirements for bringing a private right of action, and makes technical and conforming changes. Okay, so there was one arguable thing, and that it was that I'll get into this in a little bit about standing. All right, defendant, plaintiff, third party, traditional standing requirement means the requirement established by the Utah Supreme Court, so outsourcing the law to a court opinion, that a plaintiff bringing a private right of action can establish that the plaintiff has an injury in fact, causation, and redressability. It's like already, this is huge because, I don't know, just summarize this for you. This basically means that you're not allowed to civilly sue the government anymore over an unconstitutional law, unless a judge decides to let you. And in other words, you don't actually have a case. So very similar to in criminal proceedings. I've been fighting against plea bargaining for a long time and pretrial hearings a lot of Republicans are sold on the idea that those are okay and even good because they're efficient, whatever. I was just listening to Suja Thomas's book, The Missing American Jury, earlier today, and she points out the fact that nothing in the Constitution justifies the argument or action on the basis of the argument that something in government, the guarantee of this right isn't efficient enough. We need to make it more efficient. That's too expensive, right? We need to make that less expensive. We need to make this more efficient. Oh, yeah, having a judge, have a pretrial hearing with the plea deal, that's more efficient, right? Than actually having a real trial with a jury, right? And so that's one of the arguments you see a lot in criminal court and in civil litigation. Very similar arguments have been pursued. So this is doing similar things, but it's kind of a very blanket thing where they're just saying, you know, the judge basically gets to weigh in on what he thinks the outcome of the case will be before you even have a case, before you even have a civil litigation proceeding. That is catastrophic as a poison pill because it means you're not going to get fairness, you're not going to get justice, you're just going to get a government insider issuing a ruling, and depending on how he's feeling that day, maybe you get some amount of justice and redress, but most probably you won't because that's the way the system is set up. It's the government's punting on all of its true responsibilities. But let me jump into this, and maybe you're not sold on this idea yet that it's bad for judges to give an opinion before even allowing a case to be heard that yes, your injury is real, right? Isn't the jury supposed to decide that? Oh, yes, this caused that, right? Those are factually intensive things. You really should check out Suja Thomas's book, The Missing American Jury. I highly recommend it. But yeah, and redressability. Oh, can we award the right damages? Can we actually fix this, right? How's a judge going to know all that? Correct answer, the judge doesn't know any of that, right? That's not a judge's purview, frankly. And so we're going to go into this. Requirements for a private right of action. So, sorry, one more thing. This was actually my first objection to this bill. Part 1, right to sue and be sued. You do not, by law, define or establish or grant what a right is, right? Rights exist independent of all laws. The only purpose laws serve relative to rights is possibly to declare, this is, declare protections for them, right? And to provide mechanisms to ensure that they are granted, not granted, but upheld, to safeguard them, right? And so, anything in a bill by this title or addressing this topic should have to do with protecting people's right to sue and be sued. Because nothing in the Constitution limits that right. With very, very limited exception. All the exceptions are already there in the text of the Constitution, if there are any, right? So a law that purports to define that right in a way that limits it or impose additional limitations is flatly unconstitutional. And I brought this up. I told this to Brady Brammer. He did not listen. He told me kind of point blank that he doesn't agree with my interpretation of the Constitution. Anyway, so yeah, here's a mindset that governments grant rights, right? So that's red flag number 1. Again, is they're purporting to grant a right here. So the traditional standing requirement and private right of action is important to ensure that the plaintiff has a personal stake in the outcome of the action. And I'll just kind of go through this because I have a personal stake in making sure that someone else has a jury trial because that's a constitutionally protected right. And so my personal stake, hey, this is my country. That's our Constitution. If you're maltreating him, you'll maltreat me. So I have a vested interest. In fact, I have standing to sue on behalf of someone else who is injured. What this does, and everything like it does, is it's picking on the people who are weak, people who don't have enough of a voice for themselves. This is what our predatory fake criminal justice and civil litigation system does to people. It isolates them, peels away their protections, and says, oh, well, you have to defend yourself to a judge, not even to a jury. And we're not even going to let you have a jury unless we decide, unless we say so. That's abdicating their responsibilities. Dereliction of duty here. So the traditional standing requirement respects and safeguards the core constitutional principles of separation of powers by limiting a court's authority to hear only a private right of action where the plaintiff has a personal stake in the outcome of the action. Okay, that's just a lie. Like, it's a lie. They're limiting the people's rights and pretending to uphold the separation of powers. Complete lie. Okay. The traditional standing requirement protects the legal rights and interests of the person with the right to bring the private right of action. And again, like, who's the government? Who's anybody in government to say you're not allowed to, plead on someone else's behalf, right? And it's true that if you do represent someone else, this is one counterpoint that he gave, um, that I'm recollecting is he did say, well, if someone else is suing on your behalf, then you ought to be, authorized by that person to bring that suit. I think I agree with that. That yeah, you don't want to have a double jeopardy situation where someone else botches your case because that person is trying to proactively argue on your behalf without your permission. But the fact of the matter is, you do need the ability to be represented and to bring class action suits, for example, have collective bargaining. All of those things, by the way, were massively undermined during this legislative session. So the ability of people to petition the government for redress of grievances, that's practically dead now. They killed it. They killed it on purpose. I think we might have to see it happen before a lot of us might believe that that's what they did, but that's what they did. Okay. Allowing a plaintiff that does not meet the traditional standing requirement for a claim that asserts the constitutional rights of a third party in a private right of action infringes on the constitutional and statutory rights of the third party to bring a private right of action on the third party's own behalf. That's really not factual, as we just addressed. Like, it's true that if you are trying to like replace that person's voice, then that's a problem. But if you are joining your voice with theirs, I don't see any reason why that wouldn't be okay, right? So let's see. But as long as it's mutually agreed upon, right? So that they have a right to litigate on their own defense, you have a right to litigate in your own defense, and just generally bring suits against the government that like saying, hey, this is unconstitutional, you should not be doing it. So we should have that sword as well as the shield. If any of this doesn't make sense, like just let's gain more experience with this, because we were not taught how to defend our own rights in public schools. Okay, it circumvents class action laws that protect a third party from having claims litigated on third parties' behalf without the third party's knowledge or consent. And to be fair, like if there's something that does affect me as like a class or whatever, and like there's some civil litigation about the Church of Jesus Christ of Latter-day Saints, of which I'm a member, and if it affects me materially, right? I don't have to, go up to the courtroom and sit and hover over those proceedings and make sure that everything that I agree with everything that I should have the ability to do that for sure, like to go and like be apprised of things and try to and participate in the suit if I so choose and so on, like act as a witness, whatever. But like, so I understand. Again, if you're trying to litigate things, on my behalf without my consent, like there are litigations that affect us kind of regularly, honestly, and so it's a little bit disingenuous. Anyways, I don't claim to have all the right answers here, but at the same time, like you got to have a system where people are allowed to defend themselves and they're allowed to speak up in defense of the defenseless, right? That's kind of the point here. For a plaintiff to bring a private right of action, plaintiff shall meet the traditional standing right requirement of private right of action. Alrighty, and okay, and this establish this burden of proof is regardless of what your opinions are about who should be representing whom and stuff. I agree that you should have the ability to like contribute, but like if it affects you, which everything having to do with rights affects all of us, that's my number one point. And number two is even if you don't agree with that, like establish this burden of proof, right, that they're going to make before they're even going to allow the case to be heard. This is a big bummer right here. So, and this one, yeah, arguably probably enjoys even more consensus of being a poison pill. So, and you can look to the articles written on the subject for more info on that. But like, yeah, if a plaintiff brings a private right of action in a court of this state with a claim asserting the constitutional rights of a third party, the plaintiff shall establish that the third party meets the traditional standing requirement for bringing the action. The plaintiff has a substantial relationship with the third party. There is no way for the third party to bring a private right of action to assert the third party's own constitutional rights. So again, it's like, could it be possible? You're leaving that to a judge to decide. Sorry, that's a little hard. the third party's constitutional rights would be weakened without the plaintiff bringing the action. And I don't trust a judge to uphold my constitutional rights. I constitutionally asserted rights. I would trust a jury or a judge. The plaintiff in an association bringing a private right of action on behalf of any member of the association, the plaintiff shall plead with particularity. Okay, so there's a lot of burden here on the person who's pleading, right? That the member meets the traditional standing requirement for bringing private right of action. The member consents to the association bringing the action on behalf of the member, and the participation of the member is not necessary to resolution of the action. Notwithstanding subsection 1 or 2, a plaintiff may bring a private right of action in court of the state if the plaintiff is authorized by statute to bring the private right of action. So, like, here's a little government backdoor saying, okay, all right, guys, you're not allowed to, like, plead on each other's behalf unless we give you specific permission, and with this very sizable burden of proof on you in advance. And this, private right of action, you can establish the plaintiff has an injury in fact, causation, and redressability, all before a jury hears any of it. Okay, again, that's toxic. Saying basically you're not allowed to plead for others without our permission, and but also here's a backdoor for any state-sponsored actors, any state-approved actors, to be to have a backdoor and be able to pursue civil litigation if there's a law that says that they can. So it's like, you guys aren't allowed to do this, but our buddies, we're gonna make laws that say our buddies can do it. So, all right, a court shall dismiss a private right of action if the plaintiff cannot demonstrate the plaintiff meets the requirements of this section. Okay. So yeah, substantially whittled down rights of representation because they've narrowed the criteria quite. They've slathered a lot more of burden of proof on you before you're allowed to bring any civil litigation, especially with respect to any collective suits. Anyways, let me know what other questions or concerns you have with SB 203 and SB 204 and this other stuff. One of the concerns that was highlighted with SB 204, a law being challenged over its constitutionality could stay in effect until the Supreme Court makes a ruling, right? So delay tactics right here. And my friend Austin Hepworth, he's a constitutional attorney. We did a live stream with him a couple weeks back, and he's very knowledgeable on this. I highly recommend you go check out his website, believefirst.org, I think it is. Anyways, he's got a really good. He runs a YouTube channel as well. I think it's I Believe First. I'll correct myself in the chat or in the description. But he's got a lot of awareness of this because Utah just has been doubling down on these restrictions on obviously collective bargaining, like we mentioned, but also they passed this thing called the Corporate Transparency Act, which forced disclosure of lots of highly detailed private information from businesses. And it's in the name of transparency, right? But frankly, there's no enumerated power in the state constitution, or the federal for that matter, that actually authorizes our governments to have access to that information, right? And what is actually done, in fact, and with huge fines, by the way, for non-compliance, right? And it has shuttered many businesses already. And so, like, his point on this was to say, if there's a law that has, like, irreversible harm, I brought this up in the hearing. I said, this causes irreversible harm. And if you have a law that's in effect that, like, forces you to disclose stuff that's, like, your private business, your trade secrets, who knows what, your supply chain vulnerabilities, right? Your connections, like, doxing you, basically. You can't undox someone. You can't undisclose something. You can't unreveal a trade secret, right? So I'm not a super, into it kind of economics lawyer or anything like that, but anybody who has any common sense can realize that there are laws that, if passed, cause irreversible damage. And if you are not allowed to suspend the law while it's being reviewed, while it's being challenged for constitutionality, or say, have a jury hear the case and actually issue the verdict so that they can rule favorably towards you, if they determine that the law is not appropriate, we need those protections, and we need them now. We need them yesterday. We needed them 50 years ago, 100 years ago, right? We're being destroyed. We're being slaughtered by our own government. I'm sorry to be so blunt with you, but, like, if you have to either be one of those minorities that are particularly being picked on, like small business owners right here, with the Corporate Transparency Act and so on. You have to actually talk with people who are in those situations. Otherwise, you won't get it. You won't understand how our government is actually, narrowing the field. It's like a room full of people and is picking off the people in the back. You know, tying them up, shooting them with tranquilizer darts, whatever. They're hauling them away. And most of us don't care because we're like, yeah, some amount of attrition due to law enforcement is normal. That's the way we think. It's herd mentality. And yet we're not even noticing the fact that like these guys are innocent, a lot of them, or the law itself is bad. And if the law is bad, like we need to have a way to check it. Anyways, let me go ahead and just show what I found in SGR 12 about this SB 204 provision. SB 204 was amended to basically eliminate a lot of that more scary sounding stuff. I can just go ahead and type it in here. Right to appeal amendments. Again, it's like right to appeal. Well, of course you have a right to appeal, right? And the original title on this was different. I'm trying to remember what it was. But it was, yeah, super. Yeah, so the substitute here was just really different. The Court of Appeals does not have appellate jurisdiction over appeal of injunctive order. Okay, that screams consolidation of power. Anyways, I haven't done a deep dive on SB 204 since they changed the wording and changed the rules and then proceeded to pass it without another hearing, by the way. That's what they did. Because they were supposed to have another hearing in the House. They had the Senate hearing. And then they just railroaded it. They just ramrodded it through. Let me go back to SGR 12. And let me just, SGR 9. And this is where they snuck one of those things from SB 204, the original version. Filing requirements for a temporary restraining order on or a preliminary injunction of a state law. Like, so yeah, first, what's this even doing in the Transportation Committee? That's just... What's the right word for this? Malfeasance? I don't know. It's deceptive, for sure. It's deceptive. Okay. Amends the Utah Rules of Civil Procedure. So there's another... I'm just going to call it a lie. Like, if it's a non-binding resolution, but it's amending the rules of civil procedure, I'm sorry, that's binding. Okay, anyways. All right, so filing requirements for temporary restraining orders. So you say there's a state law that gets passed, and you want to ask a judge to issue a temporary restraining order on that state law with delayed implementation, right? So if it's going to take some time to take effect, an applicant must file a motion for a temporary restraining order at least 45 days before a state law takes effect. If the state law takes effect more than 60 days after the day, which almost all of these do, by the way, like you look at all the stuff that they passed in this last legislative session, it takes effect a little over 60 days after the legislative session ended, right? And so we've got like what? We've got just a few days to file a motion for a temporary restraining order on these. So let's pay attention to that, actually. Don't lose sight of that. Because a lot of these go into effect May 7th. So basically, this is our last line of defense, last way to speak up for these things. Otherwise, they're going to go ahead and start enforcing these laws. So, yeah, time is ticking. Okay. And you need to be challenging the constitutionality of the state law and seek to enjoin the execution or enforcement of state law before, sorry, I think that's an or. Seeks to enjoin the execution or enforcement of the state law before the state law becomes effective. If an applicant fails to bring a motion for a temporary restraining order under this blah 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 before the 45-day requirement, the applicant may not bring a motion for a temporary restraining order until the state law has been in effect for at least 90 days. So basically saying, we're going to have this window of enforcement that's going to be massive, and you're not going to be allowed to do anything about it. And even if it weren't massive, even if it were just like a day, if you're like, this is literally a blackout period on your right to challenge the constitutionality of laws. And I asked the sponsor, I asked Brady Brammer, and said, why is this out? Like, there is no good cause for suspending people's rights for any period of time, especially when you know that the laws can incur irreversible damages. Oh, it seems like a pretty good bill to me. Let's pass it. These guys are traitors. They're actively committing treason against our rights. Like they're... Anyways, abetting our enemies and harming our own people by preferring this legislation that steals our rights. And it's ostensibly for good purpose because we don't want to be dogpiled with all these requests, and you should figure it out well before then. I think, guys, for one, you are the ones who are dogpiling us with all this garbage legislation, and for two, there is not a legitimate reason to suspend people's rights. It doesn't exist. There is no good reason in the entire universe for anybody to be like, hey, you're not allowed to challenge the constitutionality of laws for, we'll just, steal your information, steal your stuff. Goodness knows what they're going to do. Throw you in jail for how much longer? We're going to execute people potentially. Oh, whoops, sorry, that was a bad law. Too bad we weren't even allowed to begin accepting motions to entertain the possibility that it might be unconstitutional until 90 days after we started enforcing it. These guys are criminals. These guys are criminals. I'm sorry. I don't want to mince words here. Okay, response to a motion for temporary restraining order. And notwithstanding the filing deadline for a response to a motion under Rule 7 of the Utah Rules of Civil Procedure, an adverse party must file a response to a motion for a temporary restraining order or preliminary injunction within 28 days after a motion filed if the applicant is challenging the constitutionality of state law and the applicant seeks to enjoin the execution of or enforcement of the state law before the state law becomes effective. Okay, but yeah, still having this blackout window, there is no justification for this. This is one of the most satanic things I have ever seen. This is a weapon, and they're going to use it because they're satanic criminals. Sorry, that's who's running the government. That's who this guy is. Senator Brady Brammer is a Satanist. I said it on a YouTube live stream. It is truth, okay? And I'm sorry, that's not the stuff that I know you get more flies with honey or whatever, but sorry, this is pure evil. And ask them all day. Say, hey, dude, what's with this law? Why did you pass this? Why did you pass this joint resolution amending the civil procedure on injunctions, like to have a blackout period on our right to appeal bad laws? And this is one of the reasons why we need to restore jury trials. That's vital to our survival. We cannot survive as a people without restoring jury trials because that's our final check on government. They decide, oh, we have these terrible bad laws. We're a police state now, and that's what they're creating. And I've demonstrated this through a bunch of my videos so far. They're creating a police state right now under our noses, and they do fully intend to imprison, possibly even execute people over non-offenses. And we won't have any ability to speak up because we're just like, well, yeah, people who go along with the Donald Trump and the Q narrative and stuff, they're like, oh yeah, that sounds like a really bad crime. Of course we should trust our government with police state powers. Of course we should go along with these joint resolutions that grant the government universal police powers, and that was something they just pulled out of the federal Supreme Court precedent too. It's a fictitious power of the government, traditional police powers, and that was all that they responded to me in this session when I brought that up. They said, well, the Supreme Court said that we could have that power, but my point was this is not constitutionally enumerated, guys, and you're ignoring the people's rights. You're ignoring the fact that the people have sovereignty and supremacy over the state itself. You're supposed to have limited powers. Nobody addressed that point at all. Instead, they just doubled down like these insane clowns on the federal precedent. That's what federalism means. It means you defer to the federal precedent, and it means that the states are omnipotent, right? Anyways, really bad stuff. And you know what? I'm a little bit fatigued. Been under the weather for a few days here, so pardon me. Hope you bear with me. But I just wanted to bring some attention to some of these things. I think there were some massive poison pills, like I just pointed out, in those joint resolutions, including the ones on federalism, including the ones suspending your rights for who knows what reason, right? Look out for this across all the states, and you'll see some massive things there. But yeah, we need to file those injunctions immediately to stop these bad laws. That's our next step here. in addition to just educating the public on this. But yeah, if you look at any of these calendars, it's kind of they fatigue you into compliance. That's what they do because they hit you with so many of these drones, these Satanists in our government. They'll just blow you to smithereens. And if you object to one thing, say that's unconstitutional. Oh, they snuck it into a different one, right? Different session. The Transportation Committee just took away your right to appeal against an unconstitutional law until it's too late. All right, so government operations, that's usually got some hefty poison pills. But kind of my point here is you could look at like literally any of these bills. And look, there's another by my senator. Um, and you could probably find significant poison pills. Yeah, they're they're spending money pursuant to their Commerce Clause. Okay, you can click on any of these, and I'm not remembering off the top of my head all the ones I spoke up on. Let's see, which session did I go to that afternoon? Sorry, I'm being slightly scatterbrained here because I don't remember. Was it government ops, public utilities, and energy? Oh yeah, I mentioned the SB 337. Um, some of these will be dead ends, and some of them will be nothing burgers, and they're just there to distract you and wear you out, and maybe cater to their lobbyists and so on. Those are some of the only people who show up on Capitol Hill are just the wealthy lobbyists who are like, oh yeah, we want these special deals with you, government. And the government's like, yeah, we want to give you those special deals. We want to give you subsidies as long as you let us pass laws that are corrupt and that let us continue to steal from, anyways, people. So let me look up SB 377. Was it? I'm trying to remember because that one did get a there we go. Land use and development amendments. It sounds plenty innocuous because we've already gotten used to this false idea that the government can just do whatever it wants with land and develop stuff. But this one was like, this is such a big poison pill, and I haven't yet tracked down where all of its hypertoxic provisions got migrated to, or what their next steps are on this. If they're just going to try to, you know, call a special session or run through other different parts of this. But basically, this Beehive Development Agency, in a nutshell, is it's basically its own shadow government that has control over what is it called? What do they call them? Project areas. Yeah, project plans. They get to plan projects. Don't you just love it when your government plans projects? Yeah, significant community impact project. Don't worry, it will impact you. Yes, it will. Yes, that's true. What does that even mean, guys? What does that even mean? Okay, so yeah, it describes potential revenue sources of a significant community impact project area, including property tax differential and revenue generated by certain taxes. So, like, yeah, they can identify these economic opportunity zones. What in the world is a government agency doing identifying economic opportunity zones and going and taxing without representation, by the way, to fund these pet projects and have its own police force? That's also among the provisions here to enforce whatever the heck it wants. I'm sorry, this is like, so yeah, Project 2025, all these projects. And this is part of the thing, is there's just so much that we just can't read it all. So this is one of those ones that I'm just like, okay, copy and paste the text of this bill into a, I'll leave this assignment as homework, and then we'll wrap up after I check the chats here. But take Utah's SB 337, sorry, not 377, 337. Grab the text of it, paste it into your favorite chat bot, and then just say at the top of it, say, check this for constitutional problems, and see what you get. I'm pretty sure that any self-respecting constitutional lawyer or average Joe or anybody, including a chatbot, you know, not including chatbot's not a person, but even a chatbot trained, you know, after those patterns, will not fail to detect some pretty sizable concerns here. And this is also something that's happening nationwide, by the way. I've been alerted to the fact that other states are also implementing their own practically omnipotent shadow governments that can just seize vast swaths of land and decide we're going to do this because economic opportunity and community impact because we want to do vague do-goodery under those. If you're still not sold on that idea that SGR, which one is it, 12? This idea that yeah, these traditional police powers and affect public welfare, safety, health, and morality recognized under the 10th Amendment, right? All these fictitious powers they just created out of nowhere. If you're still not sold on the fact that this is a poison pill, like look at SB 337, or if you live in a different state, look at your comparable ones. Use Citizen Portal, get some eyes on those. Again, I'm hoping to have a dashboard up here, up and running pretty soon, to where you can like actually monitor the death of your constitutionally protected liberties in real time, and that should be pretty fun as well. Fun is maybe not, it's hardly the word I'd use to describe it, but our lives are on the line. Frankly, this is hideous, and we have a responsibility to stand up and oppose this overreach. So, once again, action items. So your homework assignment here is go look up SB 337, copy and paste that whole thing. You might be able to get away with just copying the link and pasting it into your chatbot if it's able to read from the webpage. Just ask it to summarize for you, give you some talking points, give you some bullet points. Is this unconstitutional? Is this constitutionally problematic? And you can look at the text of the bill itself to verify. It's a pretty great exercise. And then secondly, per this one that I'm absolutely certain that there are like 500, maybe several thousand poison pills that I didn't catch. But I'm counting on you to go and put your eyes on things too, and to make use of these tools to summarize things and to find these other constitutional issues because, yeah, we have this deadline and the clock is ticking now that if an applicant fails to bring a motion for a temporary restraining order before the 45-day requirement, the applicant may not bring a motion for the temporary restraining order to enjoin the execution or enforcement of the state law until the state law has been in effect for at least 90 days. And yeah, it does not preclude from taking a motion for a preliminary injunction. It takes more than 60 days. Okay, and it's as of the last day of the session. So I'm going to try to put together a tracker for this, actually. But I do urge you to go and research the laws and the requirements around this for temporary restraining orders and preliminary injunctions, because they basically just tipped their hand and said, hey guys, we're passing a whole bunch of laws that are unconstitutional and that cause irreversible harms, and if you don't speak up against them before this time, then, oh, too bad, so sad. We gotta go do, haul people off to the gas chambers, or whatever we want, right? And frankly, with all the love in my heart, if you don't think this is a problem, if then you might be dumb. You might be really dumb. Like if you think that none of these things are like injurious to people's rights, and I'm sorry, and I forgive you from the bottom of my heart also, but in all eternity, I think we're going to have a hard time forgiving ourselves if we've been dumb about protecting our rights, because that's the test of this life. The war in heaven continues on the earth, and this is the test. This is the test. How do we treat people's rights? How do we respond or act, or proactively act? Do we do anything when we know that there are people on the periphery who are getting hauled off and we don't even know what's happening to them, or we don't know that that's happening? Like, we have a responsibility, we have a duty, it's a moral obligation to dispel our own ignorance and actually do something to prevent the next Holocaust, frankly. Because, yeah, a lot of the people, I've wondered before, how did the people of Nazi Germany cope with the fact that their regime was so despotic, so despicable, committing genocide? And the answer apparently is that a lot of them didn't even know about it. a lot of them maybe didn't even care to know about it. And, of those that did know, a fair proportion of them were in denial. Anyways, that's it for this one, except I'm going to go check the um, chat one last time. Seeing none, it's the phrase they use for the public comment. Checking the public for comment, seeing none. All right, all right, well, I'm going to go ahead and take a vote here, and we're passing this, not this resolution. We're passing this episode with a favorable recommendation that you check it out and that you share it and that you uh, really dive into these guts of these super gory bills here and figure out how your rights are being stolen before they're all gone. Because this is not a laughing matter. This is not a joke. This is the end game right here. All right, well, till next time, thanks for watching, and we'll see you then. Report on your homework assignment next time. SB 337, look it up, and let's keep an eye out for what we need to do with these bills, with this preliminary injunction business. Let me do a quick calculation for you on that. So May 7th is when an awful lot of these laws in Utah go into effect, and so if you have to do it 45 days in advance, April has 30 days, add 7, add another 8 from the end of April, and that would be by the 22nd. So you have until next Saturday to issue a preliminary injunction against any of these bills that just passed. So find all the poison pills and stop them. Let's do it. Thanks, team. And may the blessings of liberty be with you always. Take care.